Do you want to successfully complete the D216 Objective Assessment Exam? Then you are in the right place. Our website provides a list of questions and answers for your success in the D216 OA Exam for free. We understand that acing your OA exam can be quite challenging. That's why we provide completely free exam guides and practice questions for you. In this video, we will cover questions from legal actions, constitutional law, contract law, corporate law, and judicial concepts. So, let's get started. 1. What is an action at law? A lawsuit initiated to compel the specific performance of a contract. B. A request for an injunction or specific performance. C. A lawsuit for monetary damages or property. D. A legal request to dissolve a business entity. What do you think is the answer? Correct answer, C. A lawsuit for monetary damages or property. Explanation. Option C is correct because an action at law is a type of lawsuit where the main thing you're asking the court for is money to compensate you for some harm or loss, or to get back your property. Option A is incorrect because this describes an action in equity, seeking a specific action rather than monetary compensation. Option B is incorrect because this also describes actions in equity, focusing on injunctions or specific performance rather than monetary damages. Option D is incorrect because this is a specific type of legal request, not a general action at law seeking damages or property recovery. 2. What is an action in equity? A request for a jury trial. B. A petition for a decree such as an injunction. C. A process of selling property. D. A formal complaint to an appellate court. Can you guess the answer? Correct answer, B. A petition for a decree such as an injunction. Explanation. Option B is correct because an action in equity is a type of lawsuit where you're not just asking for money, but asking the court to issue a special order to make things fair. This could be an injunction, specific performance, or rescission. Option A is incorrect because an action in equity generally does not involve a jury trial. It is decided by a judge. Option C is incorrect because an action in equity is not simply a process of selling property, but may involve court orders affecting property rights. Option D is incorrect because an action in equity is typically initiated in a trial court, not an appellate court. 3. Who is the appellant in a court case? A. The person who wins the trial. B. The party who opposes the appeal. C. The party who appeals a court decision. D. The person who files the initial lawsuit. Can you guess the answer? Correct answer, C. The party who appeals a court decision. Explanation. Option C is correct because if a person or company loses a case in a lower court and they think the decision was wrong, they can ask a higher court to review that decision. The party who makes this request to the higher court is called the appellant. Option A is incorrect because the person who wins the trial is the appellee. Option B is incorrect because the party who opposes the appeal is the appellee or respondent. Option D is incorrect because the person who files the initial lawsuit is the plaintiff or petitioner. 4. What is binding authority? A. Any source of law a court may follow. B. Any source of law that a court must follow. C. The decision of a jury in a civil case. D. A source of law used for guidance but not mandatory. Do you know the answer? Correct answer, B. any source of law that a court must follow. Explanation. Option B is correct because binding authority, also called mandatory authority, refers to sources of law like constitutions, statutes, laws passed by legislatures, or decisions from higher courts within the same legal system that a judge must follow when they are deciding a new case. They do not have a choice, they are bound by it. Option A is incorrect because it is too broad. Option C is incorrect because it is a finding of fact, not binding authority in the same way. Option D is incorrect because it describes persuasive authority. 5. What are damages in legal terms? A violation of constitutional rights. B. Monetary compensation sought for a breach of contract or tort. C. A legal obligation imposed by statute. D. The punishment for criminal acts. Do you know the answer? Correct answer. B. Monetary compensation sought for a breach of contract or tort. Explanation. Option B is correct because in law, damages usually means money that a court orders one person or company to pay to another person or company to make up for some harm, loss, or injury they caused. This often happens if someone breaks a contract or commits a civil wrong, like negligence or defamation. Option A is incorrect because a violation of constitutional rights refers to actions that infringe upon the rights guaranteed by a country's constitution, which may lead to legal action, but is not the definition of damages. Option C is incorrect because a legal obligation imposed by statute is a duty required by law, which, if breached, might lead to damages but is not the definition of damages itself. Option D is incorrect because the punishment for criminal acts typically involves fines or imprisonment imposed by the government, whereas damages are typically awarded in the civil cases to compensate for harm. 6. What does the 14th Amendment guarantee? A. Freedom of religion. B. Protection against unreasonable searches. C. No deprivation of life, liberty, or property without due process of law. D. The right to bear arms. Do you know the answer? Correct answer. C. No deprivation of life, liberty, or property without due process of law. Explanation. Option C is correct because the 14th Amendment to the US Constitution is very important. One of its key parts is the Due Process Clause, which says that states cannot take away a person's life, liberty, or property without following fair legal procedures. It also includes the Equal Protection Clause, which means states must treat all people equally under the law. Option A is incorrect because freedom of religion is guaranteed by the First Amendment. Option B is incorrect because protection against unreasonable searches is guaranteed by the Fourth Amendment. Option D is incorrect because the right to bear arms is guaranteed by the Second Amendment. 7. What is case law? A. The regulations enacted by administrative agencies. B. The laws created by a president or executive. C. The rules of law announced in court decisions. D. The specific sections of the Constitution. Do you know the answer? Correct answer. C. The rules of law announced in court decisions. Explanation. Option C is correct because case law, also called common law or judge-made law, is made up of the legal rules, principles, and interpretations that come from the decisions made by judges in past court cases. When judges decide new cases, they often look back at how similar cases were decided before, and those past decisions help shape the law. Option A is incorrect because administrative law involves the regulations enacted by administrative agencies, not court decisions. Option B is incorrect because the laws created by a president or executive are executive orders or decrees, not case law. Option D is incorrect because constitutional law refers to the text of the Constitution itself, not interpretations developed through court cases. 8. What does corporate social responsibility mean? A. Corporations are only responsible for maximising profits. B. Corporations can and should act ethically and be accountable to society. C. Corporations must follow only the legal standards set by the government. D. CSR refers to increasing the shareholder value. Do you know the answer? Correct answer, B. Corporations can and should act ethically and be accountable to society. Explanation. Option B is correct because corporate social responsibility is the idea that businesses have a responsibility not just to make money for their owners, but also to act in ways that are good for society and the environment. This means they behave ethically, are accountable for their impact on people and the planet, and try to make a positive contribution. Option A is incorrect because focusing only on maximising profits is a limited view that doesn't consider the broader impacts of a corporation's actions. Option C is incorrect because CSR often goes beyond just meeting the minimum legal requirements and involves voluntary actions to benefit society and the environment. Option D is incorrect because while CSR can indirectly increase shareholder value, its primary focus is on ethical and societal considerations, not solely on increasing shareholder wealth. 9. What does the doctrine of preemption mean? A. Federal laws override conflicting state laws. B. State laws override conflicting federal laws. C. Local laws have authority over state laws. D. The Constitution can be amended by state legislatures. Do you know the answer? Correct answer. A. Federal laws override conflicting state laws. Explanation. Option A is correct because the doctrine of preemption is a legal principle that comes from the supremacy clause of the US Constitution. It means that if there's a conflict between a federal law and a state law, the federal law usually wins or takes precedence, and the state law is considered invalid or unenforceable in that area. Option B is incorrect because the supremacy clause dictates that federal law is supreme to state law when there is a conflict. Option C is incorrect because local laws are generally subordinate to state laws, not the other way around. Option D is incorrect because amending the Constitution involves a specific process detailed in the Constitution, not just state legislatures acting alone. 10. What is the supremacy clause? A. It gives power to state laws over federal laws. B. It states that the Constitution is the supreme law of the land. C. It establishes the Bill of Rights. D. It mandates that treaties are approved by state courts. Can you guess the answer? Correct answer, B. It states that the Constitution is the supreme law of the land. Explanation. Option B is correct because the supremacy clause is a very important part of Article 6 of the US Constitution. It basically says that the Constitution itself, plus any federal laws and treaties made according to the Constitution, are the supreme law of the land. This means they are the highest laws, and all state laws and state judges must follow them. Option A is incorrect because it is the opposite of the supremacy clause. Federal laws are supreme to state laws. Option C is incorrect because the Bill of Rights refers to the first 10 amendments to the Constitution, not the supremacy clause. Option D is incorrect because treaties are generally approved at the federal level, often involving the Senate, not state courts. 11. What does the term compelling government interest refer to? A. A government's need to ensure national security. B. The government's justification for restricting certain fundamental rights. C. The protection of citizens from crime. D. The legal basis for creating new taxes. Do you know the answer? Correct answer. B. The government's justification for restricting certain fundamental rights. Explanation. Option B is correct because compelling government interest is a very high legal standard that the government must meet if it wants to pass a law or take an action that restricts certain very important, fundamental constitutional rights like freedom of speech or religion. The government has to show that it has an extremely important reason, a compelling interest for the restriction, and that the restriction is the only way to achieve that important goal. Option A is incorrect because while ensuring national security can be a compelling interest, the term itself refers to the justification standard, not the interest itself. Option C is incorrect because while protecting citizens from crime can be a compelling interest, the term itself refers to the justification standard, not the interest itself. Option D is incorrect because the term compelling government interest is unrelated to the legal basis for creating new taxes. It is specifically related to justifying restrictions on fundamental rights. 12. What is the Fifth Amendment best known for? A. Protecting freedom of speech. B. Guaranteeing the right to vote. C. Protecting against self-incrimination and double jeopardy. D. Allowing states to enact their own laws independently. Do you know the answer? Correct answer. C. Protecting against self-incrimination and double jeopardy. Explanation. Option C is correct because the Fifth Amendment to the US Constitution provides protections against self-incrimination, meaning you cannot be forced to say anything that could make you look guilty, and double jeopardy, meaning you cannot be tried twice for the same crime if you have already been found innocent. Option A is incorrect because the First Amendment protects freedom of speech, not the Fifth. Option B is incorrect because the right to vote is covered by the 15th, 19th and 26th Amendments. Option D is incorrect because the ability of states to enact their own laws independently relates to the 10th Amendment, or federalism, not the 5th. 13. What is an appellant's role in a legal case? A. They are the party who initiates a lawsuit. B. They are the party against whom the lawsuit is filed. C. They are the party who appeals the court's decision. D. They are the judge presiding over the case. Can you guess the answer? Correct answer. C. They are the party who appeals the court's decision. Explanation. Option C is correct because if a person or company loses a case in a lower court and they believe the judge made a mistake or the decision was unfair, they can ask a higher court to review that decision. The party who makes this request to the higher court is called the appellant. Option A is incorrect because the party who initiates a lawsuit is called the plaintiff. Option B is incorrect because the party against whom the lawsuit is filed is called the defendant. Option D is incorrect because the judge presides over the case. 14. What is a dissenting opinion in a court case? A. A brief unsigned court opinion. B. An opinion where all judges agree. C. A statement by judges who disagree with the majority decision. D. A majority opinion written by one judge. Do you know the answer? Correct answer. C. A statement by judges who disagree with the majority decision. Explanation. Option C is correct because a dissenting opinion is a separate written statement by one or more judges who disagreed with the majority's decision, explaining why they think the majority was wrong. Option A is incorrect because a brief, unsigned court opinion is a per curiam opinion. Option B is incorrect because an opinion where all judges agree is a unanimous opinion. Option D is incorrect because this describes how majority opinions are often written, not a dissenting opinion. 15. What is an implied contract? A contract that must be in writing. B, a contract formed through the actions of the parties. C, a verbal agreement made in court. D, a contract that does not have any legal standing. Do you know the answer? Correct answer, B, a contract formed through the actions of the parties. Explanation. Option B is correct because an implied contract is a legally binding agreement that isn't created by explicitly stated terms. Instead, it's formed by the actions, conduct, and circumstances of the people involved, like going to a doctor for treatment and implying payment for services. Option A is incorrect because implied contracts are not defined by being in writing. Some contracts require written form, but this is not a characteristic of implied contracts. Option C is incorrect because an implied contract is not necessarily a verbal agreement made in court. It is based on the actions of the parties. Option D is incorrect because implied contracts can be legally binding and enforceable. 16. What does the term mirror image rule mean in contract law? A, the terms of the acceptance must match the offer exactly. B, the terms of the offer and acceptance can differ. C, the offer must be made in written form. D, the offerer cannot revoke an offer once accepted. Do you know the answer? Correct answer, A, the terms of the acceptance must match the offer exactly. Explanation. Option A is correct because the mirror image rule is a traditional rule in contract law that says for an acceptance of an offer to be valid and create a contract, the acceptance must be an exact, unconditional agreement to all the terms of the original offer. It has to be like a perfect mirror image of the offer, without changing anything. If the acceptance tries to change the terms, it's usually considered a counteroffer, not an acceptance. Option B is incorrect because the mirror image rule specifically requires the acceptance to be identical to the offer, not different. Option C is incorrect because the mirror image rule does not mandate that the offer be in written form. It can be oral or written. Option D is incorrect because the mirror image rule focuses on the acceptance matching the offer, not on the revocability of the offer. 17. What is a unilateral contract? A contract where both parties promise to perform. B, a contract that involves only one party. C, a contract where an offer can only be accepted by the offeree's performance. D, a contract that is invalid if not signed by both parties. Do you know the answer? Correct answer, C, a contract where an offer can only be accepted by the offeree's performance. Explanation. Option C is correct because a unilateral contract is a type of contract where one party makes a promise, but the other party doesn't make a promise in return. Instead, the only way the offeree can accept the offer and create a contract is by actually doing the specific act that the offerer requested. Option A is incorrect because it describes a bilateral contract. Option B is incorrect because contracts involve at least two parties. Option D is incorrect because it pertains to contract formalities rather than the definition of a unilateral contract. 18. What's the mailbox rule? A, the offer must be hand-delivered to be accepted. B, The acceptance is effective when dispatched. C. The offer can only be accepted via email. D. The offer is void if it is not physically mailed. What do you think is the answer? Correct answer, B. The acceptance is effective when dispatched. Explanation. Option B is correct because the mailbox rule is a rule in contract law that says when an offer is accepted by mail, the acceptance becomes legally effective, and a contract is formed as soon as the acceptance is properly sent by the person accepting the offer, not when it's actually received by the person who made the offer. Option A is incorrect because the mailbox rule applies to mailed acceptance, not hand-delivered offers. Option C is incorrect because the mailbox rule primarily deals with acceptance via mail, not exclusively email. Option D is incorrect because the offer itself isn't voided by how it is mailed. The mailbox rule addresses acceptance. 19. What is rescission in contract law? A. The termination of a contract by a court. B. The enforcement of a contract to compel performance. C. The cancellation of a contract to return parties to their pre-contract positions. D. The transfer of a contract to another party. What do you think is the answer? Correct answer, C. The cancellation of a contract to return parties to their pre-contract positions. Explanation. Option C is correct because rescission is a legal remedy that basically undoes or cancels a contract, and the goal is to put both parties back in the same position they were in before the contract was ever made. Option A is incorrect because while a court can terminate a contract, rescission specifically aims to restore the parties to their original positions, which termination alone doesn't guarantee. Option B is incorrect because enforcement of a contract or specific performance is the opposite of rescission. It seeks to uphold the contract rather than cancel it. Option D is incorrect because the transfer of a contract to another party is known as assignment or novation, not rescission, which involves cancelling the contract, not transferring it. 20. What is a fiduciary duty? A. A duty that all employees owe their employer. B. A duty to act in the best interest of another party. C. A legal requirement for contracts to be signed. D. A rule that applies to all partnerships. Do you know the answer? Correct answer. B. A duty to act in the best interest of another party. Explanation. Option B is correct because a fiduciary duty is a very special and high level of legal or ethical obligation that one person has to act solely and entirely in the best interests of another person or party, often putting that other party's interests even above their own. Option A is incorrect because while employees have duties of loyalty, the term fiduciary duty applies to a higher standard, not applied to all. Option C is incorrect because a fiduciary duty is not generally related to the legal requirements for signing contracts. Option D is incorrect because a fiduciary duty does not automatically apply to all partnerships. 21. What is the role of an independent regulatory agency? A. To report directly to the President. B. To regulate without direct control from the executive branch. C. To operate under the control of state governments. D. To handle cases of corporate fraud. Do you know the answer? Correct answer. B. To regulate without direct control from the executive branch. Explanation. Option B is correct because independent regulatory agencies are created by Congress to make and enforce rules for specific industries or areas of the economy and are designed to be somewhat insulated from direct political control by the President, often with commissioners who serve fixed terms. Option A is incorrect because independent agencies are designed to be somewhat insulated from direct political control by the president. Option C is incorrect because independent regulatory agencies are federal agencies, not state agencies. Option D is incorrect because while some independent regulatory agencies may handle cases of corporate fraud, their defining role is regulation without direct executive control. 22. What is the Commerce Clause? A law that allows states to regulate trade between them. B, a provision in the Constitution giving Congress the power to regulate interstate commerce. C, a clause that gives citizens the right to engage in free trade. D, a state law that restricts trade across state borders. Can you guess the answer? Correct answer, B, a provision in the Constitution giving Congress the power to regulate interstate commerce. Explanation. Option B is correct, because the Commerce Clause is a very important part of Article 1, Section 8 of the US Constitution, and gives the US Congress the power to regulate commerce with foreign nations, among the several states, and with the Indian tribes, which is interstate commerce. Option A is incorrect because the Commerce Clause gives power to Congress, not the states. Option C is incorrect because the Commerce Clause pertains to regulation of trade, not merely the right to engage in it. Option D is incorrect because the Commerce Clause is a federal provision, not a state law restricting trade. 23. What is the doctrine of stare decisis? A, the doctrine that courts can overrule previous decisions whenever necessary. B, a doctrine under which judges are obligated to follow precedents within their jurisdictions. C, a doctrine that allows judges to create new laws. D, a principle that requires only appellate courts to follow precedent. Can you guess the answer? Correct answer, B, a doctrine under which judges are obligated to follow precedents within their jurisdictions. Explanation. Option B is correct because stare decisis is a Latin term that means to stand by things decided. It's a fundamental legal principle in common law systems which says that judges should generally follow the decisions and legal principles that have been established in previous similar court cases that were decided by courts within their same jurisdiction, especially higher courts. This helps make the law consistent and predictable. Option A is incorrect because overruling precedent is done carefully and is not the core principle of stare decisis. Option C is incorrect because while interpreting law can create new nuances, stare decisis is fundamentally about following existing laws and precedents, not creating entirely new ones. Option D is incorrect because lower courts must also follow precedents established by higher courts within their jurisdiction, not just appellate courts. 24. What does the term breach of contract refer to? A, a court's decision to overturn a contract. B, the failure of one party to fulfill its contractual obligations. C, the mutual termination of a contract. D, a legally justified cancellation of a contract. Can you guess the answer? Correct answer, B, the failure of one party to fulfill its contractual obligations. Explanation. Option B is correct because a breach of contract happens when one or more of the people or companies who made a legally binding agreement fails to do what they promised to do according to the terms of that contract, without a good legal excuse. Option A is incorrect because it refers to a court's action, not a failure to fulfill obligations. Option C is incorrect because it describes a mutual agreement to end the contract, not a breach. Option D is incorrect because it describes a cancellation for a valid reason, implying no breach. 25. What is the Equal Protection Clause? A. A part of the Bill of Rights. B. A law guaranteeing all citizens equal employment rights. C. A provision in the 14th Amendment that guarantees no state will deny any person equal protection under the law. D. A section of the Constitution that limits Congress's legislative powers. What do you think is the answer? Correct answer, C. A provision in the 14th Amendment that guarantees no state will deny any person equal protection under the law. Explanation. Option C is correct because the Equal Protection Clause is a very important part of the 14th Amendment to the US Constitution. It says that no state shall deny to any person within its jurisdiction the equal protection of the laws, meaning that state governments must generally treat all people the same way under the law and cannot unfairly discriminate against certain groups. Option A is incorrect because the Equal Protection Clause is found in the 14th Amendment, not the Bill of Rights. Option B is incorrect because equal protection is broader than just employment rights, covering various aspects of legal treatment. Option D is incorrect because the Equal Protection Clause focuses on protecting individuals from unequal treatment by state governments, not limiting Congress's legislative powers. 26. What is meant by corporate governance? A. The structure of laws that govern civil rights. B. A set of rules defining the relationship between shareholders and a corporation. C. The process of regulating corporate taxes. D. The creation of new business regulations by Congress. Do you know the answer? Correct answer. B. A set of rules defining the relationship between shareholders and a corporation. Explanation. Option B is correct because corporate governance refers to all the rules, practices and processes that are used to direct and control a corporation. A big part of this is defining the rights and responsibilities of different groups involved in the company, especially the shareholders, the board of directors, and the top managers. Good corporate governance aims to make sure the company is run well and in the interests of its stakeholders. Option A is incorrect because corporate governance deals with company structure, not civil rights. Option C is incorrect because corporate governance is broader than just the regulation of corporate taxes. Option D is incorrect because corporate governance refers to the internal rules and practices of a corporation, not the creation of new business regulations by Congress. 27. What is a statutory law? A. Law based on judicial decisions. B. Law passed by legislative bodies such as Congress. C. Law created by administrative agencies. D. Law that is determined by public opinion. Do you know the answer? Correct answer. B. Law passed by legislative bodies such as Congress. Explanation. Option B is correct because statutory law is made up of the actual written laws that are passed by legislative bodies, like the US Congress, which makes federal statutes, or state legislatures, which make state statutes. These are the formal, codified laws of the land. Option A is incorrect because law based on judicial decisions is case law or common law, where courts interpret laws and set precedents. Option C is incorrect because law created by administrative agencies refers to administrative law or regulations, which are rules and procedures set by government agencies. Option D is incorrect because law that is determined by public opinion is not a formal source of law. While public opinion can influence legislation, it does not directly create statutory law. 28. What is a condition precedent in a contract? A. A future event that must occur for a contract to be enforceable. B. A clause that terminates the contract upon a specific event. C. a breach of contract caused by non-performance. D, a formality required to terminate a contract. What do you think is the answer? Correct answer, A, a future event that must occur for a contract to be enforceable. Explanation. Option A is correct because a condition precedent in a contract is a specific event or situation that must happen first before one or both of the parties have to perform their duties under the contract, or before the contract becomes legally binding. If the condition doesn't occur, then the obligation to perform might not arise. Option B is incorrect because it describes a condition subsequent, not a condition precedent. A condition subsequent is an event that terminates a contract. Option C is incorrect because it defines a breach of contract, which is a failure to fulfill the terms of the agreement, not a condition that must occur for the contract to be enforceable. Option D is incorrect because it refers to procedures for ending a contract, not a condition that must be met for the contract to become enforceable in the first place. 29. What is the duty of good faith in contract law? A, a legal obligation to disclose all details of the contract. B, the expectation that both parties will perform in good faith and deal fairly with each other. C, a requirement for the contract to be in writing. D, a rule that applies only to employment contracts. What do you think is the answer? Correct answer, B, the expectation that both parties will perform in good faith and deal fairly with each other. Explanation. Option B is correct because the duty of good faith and fair dealing is an implied promise in almost every contract. It means that both people or companies who enter into a contract are expected to act honestly, fairly, and reasonably towards each other when they are carrying out their promises under the contract. They shouldn't try to trick each other or do things that would prevent the other side from getting the benefits of the agreement. Option A is incorrect because it refers to a disclosure obligation, which is a separate and distinct concept from the duty of good faith. Option C is incorrect because it relates to the statute of frauds, which dictates what types of contracts must be in writing to be enforceable. Option D is incorrect because the duty of good faith applies broadly to almost every contract, not just employment contracts. 30. What is the Bill of Rights? A, the first 5 amendments to the Constitution. B, the preamble to the US Constitution. C, the first 10 amendments to the US Constitution. D, a Declaration of Independence from Britain. What do you think is the answer? Correct answer, C, the first 10 amendments to the US Constitution. Explanation. Option C is correct because the Bill of Rights refers to the first 10 amendments that were made to the US Constitution shortly after it was written. These amendments were added to protect specific individual freedoms and rights. Option A is incorrect because the Bill of Rights includes 10 amendments, not just 5. Option B is incorrect because the preamble is an introduction to the Constitution, not the Bill of Rights. Option D is incorrect because the Declaration of Independence is a separate document declaring independence from Britain. 31. What does the Fourth Amendment protect against? A, cruel and unusual punishment. B, excessive bail. C, unreasonable searches and seizures. D, involuntary servitude. Do you know the answer? Correct answer, C, unreasonable searches and seizures. Explanation. Option C is correct because the Fourth Amendment to the US Constitution protects your privacy from the government. It states that people have the right to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. This means that the police or other government officials can't search you or your property or take your things without probable cause and usually a warrant from a judge. Option A is incorrect because cruel and unusual punishment is protected against by the Eighth Amendment. Option B is incorrect because excessive bail is protected against by the Eighth Amendment. Option D is incorrect because involuntary servitude is prohibited by the 13th Amendment. 32. What is the primary function of administrative agencies? A. To create laws that supersede Congress. B. To regulate specific areas of law as mandated by legislatures. C. To enforce criminal penalties. D. To serve as appellate courts in civil cases. Can you guess the answer? Correct answer. B. To regulate specific areas of law as mandated by legislatures. Explanation. Option B is correct because administrative agencies are created by legislatures to handle and make rules for specific areas of life or business. Legislatures give them the authority to create detailed regulations, enforce those regulations, and sometimes even hold hearings and make decisions, all within the specific area they are supposed to oversee. Option A is incorrect because administrative agencies operate under authority given by legislatures. Option C is incorrect because the enforcement of criminal penalties is primarily done by the justice system, not administrative agencies. Option D is incorrect because some administrative agencies have administrative law judges, but they are not appellate courts in the judicial system. 33. What is the purpose of the Establishment Clause? A. To allow states to establish official religions. B. To prohibit the federal government from establishing a national religion. C. To grant the President authority to enact religious laws. D. To enforce uniformity in religious practices. What do you think is the answer? Correct answer. B. To prohibit the federal government from establishing a national religion. Explanation. Option B is correct because the Establishment Clause prohibits the federal government from establishing a national religion, ensuring a separation of church and state. Option A is incorrect because the Establishment Clause actually prevents states from establishing official religions by limiting federal power in religious matters. Option C is incorrect because the Establishment Clause restricts the President's ability to enact religious laws, maintaining a neutral stance on religion. Option D is incorrect because the Establishment Clause prevents the enforcement of uniformity in religious practices, promoting religious freedom and diversity. 34. What is duty-based ethics? A. A philosophy that focuses solely on achieving the greatest good for the most people. B. An ethical philosophy based on duties derived from religious or philosophical principles. C. A form of ethics that applies only to government officials. D. An ethical system that emphasizes free market principles. Can you guess the answer? Correct answer. B. An ethical philosophy based on duties derived from religious or philosophical principles. Explanation. Option B is correct because duty-based ethics, also called deontology, is an approach to morality that says whether an action is right or wrong depends on whether it follows certain moral rules, duties, or obligations. These duties might come from religious beliefs, from philosophical reasoning, or from professional codes of conduct. The focus is on doing your duty regardless of the consequences. Option A is incorrect because it describes utilitarianism, a type of consequentialism. Option C is incorrect because duty-based ethics applies to everyone, not just government officials. Option D is incorrect because duty-based ethics is based on moral duties, not free market principles. 35. What does the term mirror image rule mean in contract law? A. The acceptance must be identical to the terms of the offer. B. The contract can have different terms as long as both parties agree. C. The offeror must always provide written acceptance. D. The contract is valid if it is signed by a witness. Do you know the answer? Correct answer, A. The acceptance must be identical to the terms of the offer. Explanation. Option A is correct because the mirror image rule is a traditional rule in contract law, stating that for someone to accept an offer and create a legally binding contract, their acceptance must exactly match all the terms of the original offer. If the acceptance tries to change any of the terms, it is usually not considered an acceptance at all, but rather a rejection of the original offer and a new counter-offer. Option B is incorrect because the mirror image rule requires exact matching terms, not just agreement on different terms. Option C is incorrect because the mirror image rule does not require written acceptance from the offerer. Option D is incorrect because the mirror image rule is not about the validity of a contract based on witness signatures. 36. What is a compensatory damage award? A. Punishment for wrongdoing. B. A small token payment. C. A monetary award that compensates the injured party for actual losses. D. A payment that compensates the court for its services. What do you think is the answer? Correct answer, C. A monetary award that compensates the injured party for actual losses. Explanation. Option C is correct because compensatory damages are money that a court orders one party to pay to another party to compensate them or make up for actual harm, loss, or injury that they suffered because of the first party's wrongful act. The goal is to try and put the injured person back in the financial position they would have been in if the wrongful act hadn't happened. Option A is incorrect because punishment for wrongdoing describes punitive damages, which are intended to punish the defendant, not compensate the plaintiff. Option B is incorrect because a small token payment might be nominal damages, awarded when a legal wrong occurred but caused minimal actual harm. Option D is incorrect because a payment that compensates the court for its services describes court fees or fines, not damages paid to the injured party. 37. What is the purpose of the Eighth Amendment? A. To guarantee freedom of speech. B. To protect against excessive bail, fines, and cruel and unusual punishment. C. To protect the right to bear arms. D. To grant the right to vote. What do you think is the answer? Correct answer, B. To protect against excessive bail, fines, and cruel and unusual punishment. Explanation. Option B is correct because the Eighth Amendment to the US Constitution ensures fair treatment by the government for those accused or convicted of crimes. It prohibits excessive bail, outrageous fines, and barbaric or inhumane punishments. Option A is incorrect because the First Amendment guarantees freedom of speech. Option C is incorrect because the Second Amendment protects the right to bear arms. Option D is incorrect because the right to vote is covered by various other amendments. 38. What is an implied warranty of merchantability? A. A guarantee that goods are free from all defects. B. An assurance that goods are fit for the ordinary purposes for which such goods are used. C. A guarantee that the goods are the cheapest available. D. A requirement that the seller replace the product if requested. Can you guess the answer? Correct answer, B. An assurance that goods are fit for the ordinary purposes for which such goods are used. Explanation. Option B is correct because an implied warranty of merchantability is an unwritten automatic promise that comes with most goods sold by a merchant. It means the goods are reasonably fit for their ordinary, everyday purpose. Option A is incorrect because the warranty of merchantability doesn't guarantee goods are free from all defects, only that they meet a minimum level of quality and function. Option C is incorrect because the warranty has nothing to do with price, only the fitness of the good for its intended purpose. Option D is incorrect because the warranty doesn't require the seller to replace the product upon request. Other remedies like repair or refund might be applicable, depending on the situation. 39. What is a search warrant? A. A legal order authorising law enforcement to search property. B. A document granting immunity to the owner of a property. C. A notice to pay bail for an alleged crime. D. An order issued by the President allowing entry into any property. Can you guess the answer? Correct answer. A. A legal order authorising law enforcement to search property. Explanation. Option A is correct, because a search warrant is a written order issued by a judge or magistrate that gives law enforcement officers permission to search a specific place or person for particular items that are believed to be evidence of a crime. Option B is incorrect because a search warrant does not grant immunity. Option C is incorrect because a search warrant is not a notice to pay bail. Option D is incorrect because a search warrant is not issued by the President. 40. What is the doctrine of anticipatory repudiation? A. It allows a party to terminate a contract after performing their duties. B. It allows a party to declare they will not perform their contractual obligations before the performance is due. C. It refers to a contract clause that allows automatic renewal. D. It grants the court authority to terminate a contract without notice. What do you think is the answer? Correct answer. B. It allows a party to declare they will not perform their contractual obligations before the performance is due. Explanation. Option B is correct because anticipatory repudiation, also called anticipatory breach, in contract law happens when one party to a contract clearly tells the other party, before the time their performance is actually due, that they will not or cannot do what they promised to do in the contract. Option A is incorrect because anticipatory repudiation deals with a party declaring they will not perform before their duties are complete, not after. Option C is incorrect because anticipatory repudiation is a doctrine regarding the intent to breach a contract, not a clause for automatic renewal. Option D is incorrect because anticipatory repudiation concerns a party's declaration of non-performance, not the court's authority to terminate a contract. 41. What is a bilateral contract? A. A contract that only involves the performance of one party. B. A contract that requires both parties to perform reciprocal promises. C. A contract that is only valid when written. D. A contract that terminates after one party completes their part. What do you think is the answer? Correct answer. B. A contract that requires both parties to perform reciprocal promises. Explanation. Option B is correct because a bilateral contract is a type of agreement where both people or companies involved make promises to each other. It's a promise for a promise. For example, if I promise to pay you $100 and you promise to mow my lawn, that's a bilateral contract because we both promise to do something. Option A is incorrect because it describes a unilateral contract, which is a promise for an act. Option C is incorrect because it is related to the statute of frauds, which dictates when a contract must be in writing to be enforceable, but does not define a bilateral contract. Option D is incorrect because a bilateral contract does not terminate merely after one party completes their part. Both parties must fulfill their obligations for the contract to be fully executed. 42. What is a voidable contract? A contract that cannot be enforced by law. B, a contract that can be legally avoided at the option of one party. C, a contract that must be completed without dispute. D, a contract that is created by an oral agreement only. Do you know the answer? Correct answer. B, a contract that can be legally avoided at the option of one party. Explanation. Option B is correct because a voidable contract is a contract that is actually valid and legally binding, but one of the parties has the legal right to choose to avoid or cancel it if they want to. This might happen if, for example, one party was a minor when they made the contract, or if there was fraud, duress, or undue influence involved. Option A is incorrect because that describes a void contract, which is not a contract at all because it is not legally enforceable from the start. Option C is incorrect because a contract that must be completed without dispute describes an ideal contract situation, but does not define a voidable contract. Option D is incorrect because oral contracts can be valid, voidable, or void depending on the circumstances, and this option does not accurately define a voidable contract. 43. What is the primary function of the 10th Amendment? A, to give states all powers not delegated to the federal government. B, to regulate international trade. C, to establish federal income tax. D, to limit the rights of individual citizens. What do you think is the answer? Correct answer. A, to give states all powers not delegated to the federal government. Explanation. Option A is correct because the 10th Amendment to the US Constitution is a key part of how power is divided between the federal government and the state governments. It says that any powers that the Constitution doesn't specifically give to the federal government and doesn't specifically forbid the states from having are reserved for the states to handle or for the people themselves. This reinforces the idea of federalism and limits the power of the federal government. Option B is incorrect because regulating international trade is a power of the federal government. Option C is incorrect because federal income tax was enabled by the 16th Amendment. Option D is incorrect because the Bill of Rights primarily protects individual rights, and the 10th Amendment is part of the Bill of Rights. 44. What is the doctrine of accord and satisfaction? A legal principle that allows parties to sue for breach of contract. B, an agreement where one party agrees to accept less than originally agreed to satisfy a debt. C, a clause that terminates a contract. D, a rule that requires contracts to be signed in the presence of a notary. Can you guess the answer? Correct answer. B, an agreement where one party agrees to accept less than originally agreed to satisfy a debt. Explanation. Option B is correct because accord and satisfaction is a way to settle a debt or a disputed claim. It's a new agreement where one party offers to give something different or less than what was originally owed, and the other party agrees to accept that different performance as full payment of the original debt or claim. Once the new agreement is performed, the original debt is discharged. Option A is incorrect because it describes remedies for breach of contract, not an agreement to settle a debt. Option C is incorrect because it refers to termination clauses which deal with ending a contract, not settling a debt. Option D is incorrect because it describes contract formalities, specifically notarization, which is unrelated to accord and satisfaction. 45. What is the principle of rights in ethics? A system that protects only individual rights. B, The principle that human beings have certain fundamental rights that business decisions should not violate. C. A corporate policy that guarantees employment rights. D. A legal obligation to increase shareholder profits. Do you know the answer? Correct answer. B. The principle that human beings have certain fundamental rights that business decisions should not violate. Explanation. Option B is correct because the principle of rights, or rights-based ethics, is an ethical idea that says all human beings have certain basic, fundamental rights, like the right to life, liberty, privacy or fair treatment, simply because they are human. When businesses are making decisions, this principle suggests they should respect these fundamental human rights and not do things that would violate them. Option A is incorrect because the principle of ER rights applies to groups too, not just individuals. Option C is incorrect because a corporate policy is a specific implementation, while the principle of rights is a broader ethical concept. Option D is incorrect because the principle of rights focuses on ethical obligations to all stakeholders, not just the legal obligation to increase shareholder profits. 46. What is a liquidated damages clause? A. A provision in a contract that imposes a penalty for breach. B. A clause that stipulates an estimated amount of damages if a contract is breached. C. A section of a contract that nullifies the agreement. D. A requirement for all contracts involving more than USD 500. Can you guess the answer? Correct answer. B. A clause that stipulates an estimated amount of damages if a contract is breached. Explanation. Option B is correct because a liquidated damages clause is a part of a contract where the two sides agree on a specific amount of money that one party will have to pay to the other if they breach the contract. This amount is supposed to be a reasonable estimate of the actual damages. Option A is incorrect because if it's a penalty, courts might not enforce it. Liquidated damages are meant to compensate, not punish. Option C is incorrect because it describes a clause that voids the contract entirely, not one related to damages from a breach. Option D is incorrect because while some contracts over a certain amount may need to be in writing, a liquidated damages clause is unrelated to this requirement. 47. What is the purpose of the Lanham Act? A. To regulate contracts in interstate commerce. B. To protect manufacturers from losing business to competitors using confusingly similar trademarks. C. To create state laws governing consumer protection. D. To regulate the environmental impact of businesses. Can you guess the answer? Correct answer. B. To protect manufacturers from losing business to competitors using confusingly similar trademarks. Explanation. Option B is correct because the Lanham Act is the main federal law in the US that governs trademarks. Its purpose is to protect businesses and consumers by preventing other companies from using trademarks that are the same as or confusingly similar to existing registered trademarks. This helps prevent unfair competition and stops consumers from being tricked into buying a product from one company when they think they are buying it from another. Option A is incorrect because the regulation of contracts in interstate commerce is more related to the Commerce Clause and other laws, not specifically the Lanham Act. Option C is incorrect because creating state laws governing consumer protection is done by state legislatures, not the Lanham Act, which is a federal law. Option D is incorrect because regulating the environmental impact of businesses falls under environmental law, which is separate from the Lanham Act's focus on trademark protection. 48. What does the term guarantee refer to in business law? A. A promise to pay a debt only if the debtor defaults. B. A guarantee of performance in a bilateral contract. C. A legal promise to purchase goods under a contract. D. a clause that provides a warranty for services provided. Do you know the answer? Correct answer, A, a promise to pay a debt only if the debtor defaults. Explanation. Option A is correct because a guarantee is a legal promise made by one person to a creditor that if another person fails to pay their debt or perform their obligation, then the guarantor will step in and pay it or perform it for them. The guarantor is only responsible if the primary person defaults. Option B is incorrect because a guarantee of performance in a bilateral contract refers to the assurance that both parties will fulfill their contractual obligations, not specifically a backup payment promise. Option C is incorrect because a legal promise to purchase goods under a contract is related to a sales agreement, not a guarantee for debt payment. Option D is incorrect because a clause that provides a warranty for services provided relates to assurances about the quality or standards of service, not debt repayment. 49. What does the term tender of delivery mean? A, the transfer of goods to the buyer at the point of sale. B, the seller's act of placing conforming goods at the buyer's disposal. C, the buyer's payment before the delivery of goods. D, a condition precedent for the formation of a sales contract. Do you know the answer? Correct answer, B, the seller's act of placing conforming goods at the buyer's disposal. Explanation. Option B is correct because tender of delivery in contract law, especially for the sale of goods, means that the seller has done everything they are required to do to make the goods available to the buyer in the agreed upon way. This usually means having the conforming goods, which are goods that match what was ordered, ready at the right place and time, and notifying the buyer so they can come and get them or accept delivery. Option A is incorrect because it describes the actual delivery, not the act of tendering delivery. Option C is incorrect because it describes prepayment, which is related to payment terms, not delivery. Option D is incorrect because it refers to a condition for contract formation, whereas tender of delivery concerns contract performance. 50. What does the Uniform Commercial Code govern? A, the sale of all real estate. B, the sale of goods and tangible movable items. C, international treaties between trading partners. D, the sale of intellectual property. What do you think is the answer? Correct answer, B, the sale of goods and tangible movable items. Explanation. Option B is correct because the Uniform Commercial Code is a large set of laws adopted to make commercial transactions more consistent and predictable. Article 2 specifically governs contracts for the sale of goods, defined as tangible, movable items. Option A is incorrect because real estate is governed by real property law, not the Uniform Commercial Code. Option C is incorrect because international treaties are governed by international law, not the Uniform Commercial Code. Option D is incorrect because intellectual property is governed by intellectual property laws like patent or copyright law, not the Uniform Commercial Code. You have reached the end of our first question set. For the free complete exam preparation, visit our website link in the description, where you find thousands more practice questions and comprehensive study guides. Thanks for studying with us today. See you in the next video.